The LawAsian Association for Asia and the Pacific recently launched the publication entitled The LawAsia Toolkit on Business, Human Rights, and the Environment, a guide for lawyers in the Asia Pacific. The guidance document highlights specific elements of the UN Guiding Principles on Business and Human Rights, and in particular, its implications for legal professions in Asia Pacific. It covers the topics of business and human rights and demonstrates the links between human rights and issues related to the environment and corruption. The guidance document also underlines the importance of remediation of human rights harms and also provides guidance on how businesses and lawyers can engage and protect human rights and environmental defenders. We're in Hong Kong today at the launch of the guidance document, the LawAsia Toolkit on Business, Human Rights, and the Environment, a guide for lawyers in Asia Pacific. This guidance grew out of LawAsia's commitment to support the UN Guiding Principles on Business and Human Rights and promotion of those principles within the legal profession. And with me today is one of my co-authors, Professor Yasushi Higashizawa, who is widely considered to be one of the most preeminent legal scholars on human rights in Asia, and also serves as the co-chair of LawAsia's Human Rights Committee. Thank you for being here, Professor Higashizawa.
Thank you for inviting me.
So LawAsia certainly seems very excited to finally launch this publication. But why do you think that this guidance on business and human rights is particularly important for lawyers and other legal professionals in Asia and the Pacific?
Well, business, human rights, and the environment are intrinsically linked, and the relationship between them is of central importance in our increasing globalized economy, in which Asia is often viewed as a workshop of the world. Increased business activities in the region has resulted in rapid economic growth, of course. This in turn has caused novel problems in the region, such as widening gaps between the rich and the poor, increased strains on social systems, and destruction of natural environment on which local people rely. So it's become critical that we pay more attention to the impact of business on human rights and environment.
But why the focus on lawyers in particular?
Yes, lawyers play an important role on business transactions and cross-national issues concerning business and human rights. They are well placed to advise companies on what they should do to fulfill their obligations regarding human rights and environment laws and expectations. As well as lawyers can assist individuals or victims whose rights may have been adversely impacted by business. So, what is required for lawyers? It's not just to stick to the law and regulations of their own jurisdictions, as is the case with traditional lawyering, but rather they must take into consideration the international expectations related to business, human rights, and the environment in order to provide effective legal services to their client. Increasingly, a transnational business can face legal actions in their home jurisdiction for issues that occur abroad. This is particularly the case when businesses are operating in insufficiently regulated areas or in jurisdictions where enforcement mechanisms are so weak. So, it's important that lawyers in the region are aware of these international expectations when it comes to business, human rights, and the environment. This document provides lawyers who practice in the Asia-Pacific region with information and checkpoints on how they can address the relationship between business and human rights and environmental issues, whether they are advising business on how to be more socially responsible or helping victims to access remedies through local or international measures.
Now, it's important to note that the guiding principles on business and human rights do not constitute a formalized international instrument that can be ratified by states, nor do they create new legal obligations for businesses. So if they're not a legal instrument per se, why is it so important that businesses and the legal community sit up and take notice?
It's true. The UNGPs do not create any new legal obligations. Rather, they clarify the implication of existing international human rights standards. Of course, some of which are very much legally binding on states. However, it is time for lawyers and business entities to get rid of this thinking of whether it is legally binding or not. For business to be sustainable, it is not enough for them to clear only locally and legally binding obligations. Rather, they must respond to international risks and expectations. The UNGPs make it clear that business activities are constrained by their responsibility to respect human rights whenever or however they operate. While human rights due diligence and the remediation of harm may not specifically be legally required, they are necessary if a company is to know and show that it is meeting its responsibility to respect human rights. Even if it is not necessarily subject to a legal court, the company will be faced the court of public opinion, comprising employees, communities, consumers, civil societies, as well as investors. So there can be legal, financial, and reputational consequences if companies fail to respect human rights. And legal professionals need to be aware of this. This is what this guidance is all about.
Professor Higashizawa, I thank you very much for your time.
Yeah, thank you, David, and thank you for your collaboration on this project.